Hello.
Hi, Professor.
Hi. Good, we're here. Good.
Hello, everybody at home. Can you hear me?
Yep.
Okay,
Yep.
sounds good. Everyone in class who has a laptop, please hook into your Zoom and we'll get going. We don't have a ton of material to cover today, but we have a lot of cases to cover today. And I'd like to get through them and sort of put this behind us. We're going to finish up mootness, we're going to finish up standing, mainly finish up constitutional standing, then get into prudential standing. That's where there are a number of cases. We'll run through those. And then the ripeness doctrine is not a hard doctrine to understand. Unfortunately, the Supreme Court is all over the place in regard to ripeness. So it's a hard doctrine to apply while it's not hard to understand. And there's a bunch of cases there that I want to get through. So I got 60 slides, but most of these slides are going to be fairly quick, sort of hit and run types of slides, okay? So we had introduced constitutional standing. Are we ready to do this all together? What are the three elements of constitutional standing?
Injury in fact.
Okay, let's start again. I need you all to participate. Ready?
Yes. Injury in fact. Injury in fact.
Causation.
Redressability.
Injury in fact, causation, and redressability. I'm going to start taking attendance again, starting the next class. Spread the word. This is ridiculous. I've got 19 students here in total, and this class has 40 students in the daytime on it. I understand that some people go at night.
Isn't the other half at home?
But tell your friends that we're going to start taking attendance again. Watching them on tape is not the same as watching live when you can ask questions. It's bad enough that we can't do this live. It's no one's fault that we can't. And I would prefer to do it live. And if we did it live, I'd be calling on people and would be interacting a lot more than we are now. But this is a pretty poor attendance for the live class, and I don't like it.
Isn't the
I
second?
don't like it at all.
Aren't the rest of us at home?
I think it tends to show laziness.
Yeah, but
I'm a pretty nice guy. I'm a pretty easygoing guy. I try to make this as fun and interesting for you as I can. I know it's a tough subject, but if you don't give a damn, then you're going to pay the price for it. It's as simple as that.
You're talking
to law school. You're going to be lawyers.
You're talking.
I know I'm preaching to the choir because I'm talking to those who are here. Those who decide to watch it later on tonight on tape will hear this. Okay. You got to put in an effort to be a lawyer. This is one of the hardest things that you will ever do. The bar exam is the hardest exam that you will ever take. I wish I could give you an exam as hard as the bar exam, because my job is to prepare you, not to be your friend, not to let you off easy. My job is to prepare you for the bar exam. And when I see mediocre effort in law school, it makes me incredibly angry, because you're wasting an opportunity. You're paying for this, and you're wasting an opportunity, and it makes me angry. So, all right, let's put this behind me, back into nice mode. We had established the elements of causation. We had started to focus mainly on injury in fact. Most of the cases we looked at on Tuesday were injury in fact. By the way, the quiz will be posted first thing in the morning. I will give you until Monday evening at 11 o'clock to do it. So you'll have a window of Friday, Saturday, Sunday, and Monday if you choose to do it. You guys know that once you start it, you have to finish it within your time, right? So that'll be up. You also know that the quizzes are randomized. None of you get the exact same quiz in the same order. It's all the same quiz, but you won't be getting the questions in the same order. So you can't call up your friends and say A, D, B, D, C, A, okay? All right, let's move on and focus on the cases that mainly deal with causation and redressability. And I think what you'll see are the two big areas: injury in fact, causation, redressability. The two big out of the three are going to be injury in fact, and to a far lesser degree redressability, but redressability a little bit more than causation. Those are going to be the ones that the court seems to focus on. I also want you to observe as we're going through these cases that there's overlap between these issues. Sometimes when there's no injury, there's also no redressability, right? And so these are nice, tight little compartments that are, you know, their own little continents. These are symbiotically related, and there is overlap between them. So let's run through these cases fairly quickly, see where the court is going on this. We established the tension here on Tuesday that we're going to see. Non-activist judges, judges who call themselves originalists, judges who tend to be appointed by Republican governments. That's not presidents. That's not a political comment. That's an observation. Those Supreme Court judges tend to be more willing to dismiss on standing than non-originalist justices, more activist justices, those who tend to be appointed by Democratic presidents, okay? And again, there's no right answer and wrong answer here. And my advice to you is always, well, how do I know how to answer the question? What you need to know how to do is to understand that the three elements are injury in fact, causation, and redressability, and apply them. And on an essay, the least important thing is your conclusion. The most important thing is that you know the elements and that you are able to understand the logical flow of the elements, and you're able to do a cogent analysis to support your conclusion. I don't give a damn what your conclusion is. You know, when reasonable, unless it's a ridiculous, illogical conclusion. But when reasonable minds can differ, you don't get marked down in the least bit. This is not a class on politics. You don't get marked down in the least bit if I might personally disagree with your conclusion, okay? All right. Linda R.S. versus Richard D. So Texas has this law that says married fathers who have children who fail to pay child support can be prosecuted by the state. The law, unfortunately, for the plaintiff here, does not provide that unmarried fathers of children can be prosecuted for failure to pay child support. So in cases where unwed fathers get a judgment of child support against them, in Massachusetts, that would be in the probate court. Paternity would be adjudicated, and an entry of an order of child support would be made. If the unwed fathers don't pay it, they will not be thrown in jail. But if the married fathers refuse to pay it, they will be thrown in jail. I did not practice domestic relations law. I had a partner who did. And it is an incredibly effective way of getting child support paid. When the probate court judge says, I've given you several opportunities to pay the child support, you haven't paid it. Enjoy 30 days in the slammer and see how you like it then. If you can come up with the money you claim you don't have now, before then I'll let you out earlier. It's shocking how many people, once they get into jail, find a way to get the money to pay the back child support, right?
Professor.
It's a fairly effective remedy.
Professor.
So this unwed mother sued, claiming that the statute was unconstitutional, essentially discriminated against unwed mothers, protected married mothers. She wanted the father of her child to be prosecuted for failure to pay child support. And this is a case decided on pure redressability. The Supreme Court says, well, look, even if we can grant you your relief, even if we can say the statute is unconstitutional and this guy has to be prosecuted, the result of that is going to be that he's going to be thrown in jail. The result is not necessarily going to be that he ends up paying the child support. He'll be thrown in jail and not pay the child support. So you don't get redressability of that which you seek, which is the payment of child support, okay? And that's what these redressability cases look like. Even if we could give you what you wanted, you would not necessarily get what you wanted. Worth v. Selden. Do I have anyone who's on their zoning boards, local zoning boards, planning board or board of appeals or anything like that? No? Do I have anyone who's ever been to a zoning meeting, participated in zoning meetings before? A couple of you seem to
I went to one.
Zoning is relatively the same from state to state. There are often different names for the boards and different names for some of the relief that's sought, but they're all essentially the same thing, just with different names. There is this concept in zoning law called exclusionary zoning. And let's just quickly sort of set this out. It is a, it'll come up again in equal protection cases. Here it's up in regard to a standing issue. Towns that are very well managed, have a nice tax base, and plan for growth. Towns and cities that are very well managed, have a good tax base, usually based on the value of the real estate. If they want to have money in the account, they typically have a mixture of residential taxes and commercial taxes that they are collecting. In states like Massachusetts, you can actually charge a higher rate for commercial taxes than you can for residential taxes. There are some towns called bedroom towns that don't have a large commercial base. They tend to have very high residential taxes as a result of it. In order to sort of control the amount of money that comes in and to keep the taxes down, the town needs to plan for growth. When towns grow too quickly, there is a big problem. And there have been a couple of towns in Massachusetts that at one point that I know of, I bet you there's even more, that at one point were the fastest growing towns in the country. In the late 60s and early 70s, Burlington, Massachusetts grew incredibly fast at about the time that the Burlington Mall came in. And there was another town sort of down in sort of southeast, the Blackstone Valley area of Massachusetts, Franklin, Massachusetts, that at one point was the fastest growing town in the country. What happens when a town unexpectedly grows fast? The school system gets strained. What happens when the school system gets strained? You have to build more schools, right? So towns want to control growth. They'll accept it, but they want it controlled and they don't want it to happen too quickly. And what's the easiest thing a town can do to prevent excessive population growth? Teddy? Nope, not necessarily. Kerry. I'll repeat your question, your answer. And how would you, Kerry says control building. How would you control building? Yeah, that's probably the easiest way to do it. Is you, Terry said control building by increasing the minimum lot sizes, the amount of acreage you need to build single family and multiple family dwellings. And that is, in fact, a very, very easy way to do it. So if the town is predominantly half-acre zoning, you turn it into acre zoning. Number one, that's going to mean that fewer people are going to come because they have to build, you know, they have to buy bigger lots in order to build, right? So you make the zoning more restrictive. That also has the effect of increasing the value of the land, which, although it doesn't increase the tax rate, it does increase the amount of taxes that are going to be paid. And what does that result in? That results in what is called exclusionary zoning. Now, the town is doing something that's laudable. The town is trying to control its growth. But by making the land more valuable and more unaffordable, what is it also doing? It is decreasing the number of people who are lower on the socioeconomic ladder from being able to move into the town. And often this is related to race. So it creates both a race issue and a socioeconomic issue. And then it has another effect, of course, is, and you guys know this story, your generation knows this story as well as anyone, since real estate prices are historically high right now. The town I grew up in, I can't afford to buy a house in because the real estate values have gone up. So when this has a discriminatory effect on the basis of class and on the basis of race, the general phrase for it is exclusionary zoning. In different states have different ways to deal with exclusionary zoning. Massachusetts has something that's very controversial called the Anti-Snob Zoning Law, the Anti-Snob Zoning Act. Some of you who have done developing may know it in Massachusetts, it's Chapter 40B. And when developers hear 40B, they go, whoopee, 40B means I'm not going to have to follow all the zoning laws. And when the towns hear 40B, and a lot of the townspeople hear 40B, they say, oh, here we go, another multi-housing project that's going to be built in our town.
Does that go hand in hand with the?
We'll deal with that, you know, a little bit later on. Professor Capani teaches a land use course, and he would deal with that in the land use course, this issue of exclusionary zoning. Well, why did I go into that long lead up? Worth v. Selden is an exclusionary zoning case. It happens in New York instead of Massachusetts, where there is no Chapter 40B in New York, or no equivalent of Chapter 40B, at least in 1975. There was no equivalent of Chapter 40B. So here, the plaintiffs are people who live in Rochester, New York. Penfield is a suburb, undoubtedly a more affluent place than Rochester. These folks looked at the Penfield. They wanted to buy in Penfield. They wanted to move to Penfield. What's the big benefit of moving to a more affluent town almost always? Teddy? Nope. You sound like our president.
Jay here.
Nope.
Jay,
Gary?
is it the value?
School system.
School systems.
Right? Parents want their kids to go to a good school system so they get a good education so they can go to a good college, right? That's a huge advantage. And unfortunately, it is part of our sort of economic, strata that wealthy towns have good school systems. And less wealthy towns sometimes have good school systems, but that's the exception as opposed to the rule. Okay. So, you can see why these parents would want to move into a more affluent town that presumably, I don't know the area. I can tell you the only thing I know about Rochester, New York is Eastman Kodak. I can tell you two things. Eastman Kodak was there. And I can tell you, if you want to know anything, any fact that doesn't matter, ask me. Okay, I tend to absorb these things. If you want to find out something important, don't ask me, because I don't know that stuff. Rochester, New York, is usually the least sunny city in the United States. It's got the lake effect that's in the snow belt up in upper New York, so it gets a lot of rain and a lot of snow. They claim that they want to move to Penfield. They're persons of low and moderate income, and they can't move there because of the exclusionary zoning that Penfield has. So they bring a claim against the city of Penfield, the town of Penfield, saying that its zoning practices are exclusionary and thus discriminatory. The Supreme Court throws it out saying that you have no standing. Now, they're not saying that they aren't injured by this. What they say instead is that there is no redressability, that the claim is much too vague to show that there is any redressability. They say that you haven't made any claim that even if the zoning laws were to change, that you would still be able to move there. There might be a panoply of other reasons preventing you from moving there. You don't have standing for that claim, okay? And again, that would be on the side of the court that tends not, to be willing to dismiss cases based on standing. Similar case, Simon versus Eastern Kentucky Welfare Rights Organization. During the pandemic, why do you not walk into an emergency room in a hospital unless you absolutely have to? Because who is there in the emergency room?
You'll get
Sick
sick.
Generally, people without health care, people who can't afford health care, often indigent people. They have no choice but to go to the emergency rooms. And as a result of that, most hospitals that get federal and state funding are required to accept a certain number of individual patients and provide free medical care to them, okay? And that's what this case is about. A federal law, in order to get, a favorable tax treatment, the federal law requires hospitals to provide free care to a certain number of indigents on a periodic basis. It then, the IRS revises the rule, which your casebook is not absolutely clear on, but it's pretty implicit, that it essentially reduces the number of indigent people that the hospital has to accept to continue to get its tax exempt status. Individuals who claimed that they were denied free medical care from the hospital sued, and the Supreme Court again dismissed on the ground that the plaintiffs lacked standing, purely speculative to assert that the revenue ruling was responsible for the denial of medical services to the plaintiffs. The complaint suggested that no substantial likelihood that a victory would result in them receiving free hospital care they deserved, no causation, no redressability. Again, we get into the whole question here, and this is what you see the two sides arguing about in standing is what level of proof does a plaintiff have to provide in the complaint at the initiation of the lawsuit? Those who want sort of broader access to litigation, in other words, those who don't want standing applied real strictly, think that the showing doesn't have to be all that strong at the beginning. Those who want less access to the ability to litigate, those who want to apply standing more strictly, think that there has to be a higher quantum of evidence of injury, causation, and redressability provided at the onset of the litigation. And there's no clear standard that the court has come up with. So for example, you guys know real clearly 12b-6, right? What's the standard under 12b-6? Motion to dismiss for failure to state a claim upon which
Relief can be,
granted, right?
yes.
And the Supreme Court has made the burden even greater for plaintiffs under 12b-6 these days, okay? And you guys know that under Rule 56, which seeks a dismissal of the case, summary judgment, there are no material facts in dispute, and the moving party is entitled to judgment as a matter of law, right? That's basically the standard there. Those are fairly precise standards. Those are yardsticks that you can use to measure what kind of evidence, what kind of showing of evidence is important. The Supreme Court has not come up with a real clear standard on standing cases. And so you see the majority and minorities, you know, depending on which side they're on, bickering with each other. You know, this is enough evidence, no, it's not, type thing, okay? All right, Duke Power Company versus Carolina Environmental Study Group, 1978. Please note the year, 1978. I'm going to date myself. It's the year I graduated from college and the year I started law school, 1978. Did I tell you that I was 11 years old when I started law school? I wish I were 11 years old when I started law school. The nuclear energy industry is incredibly highly regulated. It's a very, very highly regulated industry, and probably with good reason. It's highly regulated because if these nuclear power plants are not built properly, they are major safety hazards and environmental hazards as well. And the United States has set up a system, the critics of it would say has set up a system that has made nuclear power unaffordable. Whereas those who are anti-nukers would claim they've set up a system that makes the American nuclear power industry safer than most of the rest of the world. Countries like France and Japan derive most of their electricity through nuclear power plants, whereas in the United States, relatively little of our electrical power is derived from nuclear power plants. The issue in policy-wise, the issue of nuclear power is sort of back in the discussion again. In the 1970s, there was a whole no nukes movement. And there was actually a concert to raise money for anti-nukes. Who do I have here from the seacoast of New Hampshire? Is anyone, or at least familiar with the seacoast of New Hampshire? You've obviously got the Seabrook nuclear power plant. There was a large organization of people who called themselves the Clamshell Alliance, who were strongly opposed to the building of the plant. It would come in and try to block the construction workers as they were coming in to build it. This used to be a very, very controversial figure. It's back in the news today because when we talk about climate change caused by greenhouse gases, the one big advantage of nuclear power is that it does not put carbon into the atmosphere. Does not put carbon dioxide into the atmosphere, so it doesn't create greenhouse gases. On the other hand, there's a couple of fears of nuclear power plants, which is that radiation can escape into the nearby community, number one. And number two, there is always the threat of a nuclear meltdown. And there hasn't ever been a complete nuclear meltdown, but we'll talk more about that in a few minutes. There've been partial nuclear power plant meltdowns. So when the laws regulating the building of nuclear power plants were created, built into those laws was a certain level of immunity to the power companies that built the power plants, okay? So here we're looking at the Price-Anderson Act, which limits the liability of utility companies if there is a nuclear reactor accident. You know, in full disclosure, not a complete waiver of liability, but a limitation of liability in the event that something like that happened. Here you have some individuals in some organizations who are fairly close to the nuclear power plant, at least the individuals are. They challenge the constitutionality of the law. At this point, in the United States, no nuclear accident had ever occurred. No one had ever been denied compensation because there's never been an accident. And no one had suffered an injury at that point. So then the question becomes, well, what is their injury in fact? And, you know, what is their redressability if a judgment is issued? The Supreme Court here found that there was standing, and that's in the third paragraph of this slide. Construction of the nuclear reactor subjected area residents to the exposure of radiation, thermal pollution, in fear of a major nuclear accident. Causation and redressability were met because but for the act, the reactor would not be built and the plaintiffs would not suffer these harms. In other words, the limitation of liability made it affordable for the power companies to build these plants. It otherwise would have been unaffordable for them to do that, and the plants would not have been built, right? The court says you have standing, you can go on and litigate the case. Postscript, the case is eventually litigated and the statute is upheld. So the Duke Power Company won on substantive grounds, but lost on the question of standing in this case, okay? All right, I got a multiple choice question. I'm gonna give it to you. I'm gonna read it to you. I'm gonna let you guys talk to each other for a moment about it. I think you're gonna be able to power through this fairly quickly. After I read it to you and I let you talk to each other for about 2 or 3 minutes, I'm gonna ask you to mute your computers. You know what's gonna happen if you talk to each other and everyone's coming over at the speakers at the same time, right? It's gonna be mayhem in here. So, actually, those of you at home can't do that, right?
We can't, that's not big enough yet.
Yeah, no, I can do a chat room, but I'm not gonna do that here. I'm just gonna have you guys think about this for a minute and then we'll go through the answers, okay? All right. I'm used to doing that. Those of you who had me for property last semester know that I like to put these up, let you talk to each other about it. You form your own groups, and you tend to learn something by talking to each other. You go through all the pros and cons, and then we come back and go through them and we look at the answer together. I don't think I can do that here, given the forum that we have. I can, and I haven't done it yet. I can set up chat rooms for you guys. I can make them random, and I can put a certain number of you in each chat room and let you talk to each other in that regard. The reason I'm not doing that here is because I apparently have more students in the classroom than I have at home. It would be kind of a buzz going on in here as well. So
Can I ask a
we'll just
question?
look at this and go through it.
Can I ask a question about the standing?
This is a hypothetical case. This is not anything that's going to happen anytime soon. It's based on the way things used to be. U.S. military commitments have taxed the armed forces to the point that Congress has revived the draft. I had a draft card when I turned 18 years of age. The Vietnam War was still going on. The Vietnam War didn't end until 1975. I turned 18 in 1974. But we had stopped sending draftees over to Vietnam 1 year before I turned 18 years old. So I was a pure accident of birth and not getting drafted for the war. I was born a year too late for that. But I was still required to do a draft card. Those of you who are men and who are here today, you don't get draft cards, but you did have to register for the draft, right? You don't get student loans unless you register for the draft when you turn 18. And I don't know, my sons have some computer printout somewhere that we kept to prove that they registered for the draft. But in my day, I literally had to carry it on my person. That was the law. So I had to put it in my wallet and keep it with me at all times. I didn't know if anyone ever getting, a cop wouldn't walk up to you and say, "Do you have a draft card?" It didn't happen like that, but you were required to have it on your person. All right. So the United States Congress revives the draft. Men between the ages of 18 and 25 are subject to the draft and are chosen by a lottery system. This is exactly the way it happened. The 365 birthdays are thrown into a bin and drawn in order. The first birthday drawn receives the number 1, and the last drawn receives the number 365. Those drawing low numbers are called up first. Those whose numbers are less than about 100, are more, that's a typo, whose numbers are more than about 150 are very unlikely to be called up for the draft. My number, as it turned out, even though I wouldn't have gone under any circumstances, was close to 300. I call that the only lottery I've ever won, and it didn't count, right? Because my number meant that I would not have been drafted, but I was not going to be drafted anyways. At that point, I was going to college. So which of the following plaintiffs is most likely to have standing in a lawsuit challenging the legality of the draft? A, the parents of a 17-year-old male alleging that the draft is unconstitutional in the absence of a constitutional declaration of war. B, a 19-year-old female who argues that the draft violates the 13th Amendment's ban on involuntary servitude. C, an 18-year-old male who fears his lottery number will be low in the lottery to be held the next month. D, the parents of an 18-year-old male alleging that the draft is unconstitutional in the absence of a congressional declaration of war. Okay?
C,
Think about that for a minute, and then I'll take a couple of volunteers.
maybe C.
Now, don't talk. It'll create too many problems with the technology. We'll wait for just a minute or second. Karen seems to be the first one with her hand, but I'm going to ask you to hold it, Karen, just for a moment. And then Teddy, and first name again? Oh, Roberto. I'm sorry, Roberto. What do I think would have happened if I did get drafted? I wouldn't have been in Canada. I know that. The draft, I'm just going to talk quickly about a little history here. The draft was created because typically the way that America has worked when it comes to fighting wars is that the rich are exempted from fighting and the poor are have to fight on behalf of the country. And the whole idea of the draft was that it would create more equality, that both the rich and the poor became subject to, having to fight the war. Unfortunately, the draft was not all that well conceived, at least in Vietnam, because the rich had the resources to find ways to get out of having to serve, even if their numbers came in low. They usually found a way to get a medical exemption, okay? It didn't end up being as fair as it should have been, okay? All right, so I think the order that I've got queued up here is Karen and then Roberto and then Teddy. So Karen, Are you ready to
Okay.
talk?
Yes, I was just looking in my book for something, but yeah, I was gonna
Hear
say,
what Karen is saying. Can you guys
I
hear
was,
Karen?
can you hear me? No? You can't hear me? You can hear me? Yeah? Okay.
My volume, I think, is up. It's 100.
Roger, you can
I
hear
don't
me?
hear Karen. Does anyone hear Karen?
Roger hears me. She's shaking her head.
I
We
can
are
also
at
hear
home.
you.
Can you hear any of us at
I
home?
hear you.
Karen, hold on for a
I can
second. I'm
hear
not
you.
hearing you. Everyone else is. I'm not,
Okay.
which means I might have to adjust my audio settings. Karen, please try speaking again.
Hi, can you hear me?
Now I can hear you,
All right,
Karen. That was
good.
me. My
Good.
apologies. Go ahead.
Sorry, I'm glad it's not on my end. I was saying C, because he's the first one that would be picked. He's 18 years old. He has standing because he's directly affected. So I think that would be the best answer over the other three. With B, I would throw out because that has nothing to do with this. And then A and D are close, but C I think is the best because he's directly affected. And yeah, that's what I was gonna say. Do you want me to do the order of preference? No?
Nope, that's fine.
Okay.
Karen says C is the best. She says that's the person who is closest to being drafted. And the others don't sort of rank. I'm sort of shortening and paraphrasing what she said. Roberto, you say B, and why B?
Hmm.
Okay, 13th Amendment, involuntary servitude. Okay, Teddy? Okay. Let's take a look at B and D at the same time, okay? In both of these, now remember, what are you going to do with a multiple choice question? Not just read them all, eliminate. And if you eliminate and you have only one standing, you've got the right answer, right? And if you eliminate and you've got two standing, this is what you got to do on everyone with a minimum. You got to get it down to two choices, okay? Because then at least you have a 50-50 chance of getting it right. Otherwise, otherwise it's finding the needle in the haystack. Not quite that bad, but your odds are pretty low if they're 1 out of 4. Okay. Now remember here, the idea is this is really, I think, focusing on injury in fact. Okay. So who here is sustaining the most injury? And I submit to you that the age of the person has something to do with this, okay? What happens to all people, men and women, when they turn 18 years of age in the United States? They become emancipated from their parents, right? They are old enough to vote. Yeah, many of them live at home until they're in their 30s. Okay, I'm Italian. I know that. It's in Italy. It is a particular problem of sons living at home until they're into their mid-30s. They like mama's cooking and homemaking, I guess. People are emancipated when they turn 18 years of age. So when I take a look at D as in dog, this is the very first one that I throw out, because parents don't have any responsibility or in control over that person anymore, and they cannot bring a lawsuit on his behalf as a general matter. He has to do it himself. And if the parents are bringing the lawsuit, and we'll talk a little bit about this more when we get to third-party standing, when we do prudential standing in just a moment, the parents of the 18-year-old don't have a dog in the fight. They have no harm themselves, no cognizable harm, at least themselves. Are they going to worry about their son while the son is overseas fighting? Of course, okay? But they don't have, you know, a strong enough claim of injury to challenge this. So I throw D out right away. The second one I throw out is B. And the reason I throw out is B is because who is subject to the draft? Males.
Men.
Is there any chance that the 19-year-old female is going to be drafted?
Only in Israel.
Well, there you go.
Maybe
Or
other
at least-
countries, but
at
not
least
here.
Israel. I don't know if there are other countries or not, but we all know that everyone has to do a military stint in Israel. A lot of what? Oh, well, I'll pretend I didn't hear that one, Ted. I could throw out B as well, which brings us down to A, or brings us down to C. And now we have to choose, okay, both of these people are potentially subject to injury in fact. You know, they're claiming that the draft is unconstitutional, and they're claiming that they're going to suffer as a result thereby. But the question asks you, which of the following is most likely to have standing? So you now have to weigh A against C. And the thing that tips it in favor of C is that the day I turned 18, you know, I was supposed to, within a very short period of time, register for the draft. And typically you are, you know, shipped out by the time you turn 19 years of age. And the person who was closest to this is the 18-year-old male. Now, you don't have to say that the 18-year-old male is definitely going overseas here, because it asks you which is the most likely. It is possible that the 18-year-old male may get a number in the 300s, right? And not have to go. And so there is still an argument that even for C, the 18-year-old's claim is speculative. Okay?
Professor?
But it is less speculative than it is for A. And A is
Professor? So I have a question.
Yeah.
This is Eunice.
Linda, whoa.
It's not Linda, it's Eunice.
Oh, is it? Yes, Eunice, I'm sorry. Eunice, yeah, that's fine. You just have to wait until I'm done talking. Okay? Go ahead. Go ahead.
So I had a question regarding, so my initial answer was C, but then when someone mentioned B, I questioned whether B would be the correct answer, and I'm just thinking out loud.
No.
C is not challenging the legality. To me, now that I'm looking at it, it doesn't seem to me that C is challenging the legality based on the question. Which of the following plaintiff is most likely to have a
What is the issue? What is, Eunice, what is the issue we're dealing with on this question? Is it
standing?
the substantive claim, or is it whether the court has standing to hear the case?
Well, so that's really that, and that is the reason I'm asking the question, because B is challenging that because it excludes.
No, stop, Eunice, stop. What does the substance of the claim have to do with standing?
Whether they have whether they will be directly injured, whether they have
That's not
have a claim in the game.
That has nothing to do with whether there's a legitimate claim or not. That's a different question. That's a 12b6 question, right? This is a standing question. The standing question only asks whether the plaintiff has sufficient skin in the game. And when it comes to standing, the substance of the claim has nothing to do with this, okay? So the bottom line is, and I'm gonna tell you two things here. So the bottom line is that, you know, the court is saying, we assume that your claim is valid. That is not the question before us in standing. What is the question before us? Do you have skin in the game? Do you have enough to go forward? If you say what you say is correct, if you say that it is the 13th Amendment constitutional violation, Are you going to be injured by it? And what do we know about the person in B? Even if she's correct that it violates the 13th Amendment, which it is not correct, by the way. The 13th Amendment excludes imprisonment
Right.
and things like conscription. Okay.
She's female.
She can't be drafted. So, that sounds Sam said she's not in the zone of interest. That's a guy who recently took torts, as I can tell, but it is an analogous, it is an analogy that's kind of apt here, okay? So Sam, Eunice, this is good that you asked this question and that we work this out, okay? Because, you know, part of the reason we do this give and take here is to help us work out what don't I consider when I'm doing standing, what do I consider when I'm doing standing. Now, what you just told me was a perfectly valid claim if it were a 12B6 motion to dismiss. You know, if the case were brought in the federal courts, 12B6 would apply. Failure to state a claim upon which relief can be granted. And what you're telling us is a valid point, Eunice, which is that C doesn't seem to have a lot of substance to it, right? And C may well not survive a 12B6 motion. But that's not the issue before us. The issue before us is there standing here? And so that's why C is a better answer than B. And B is one of the worst answers because the female, even if she's totally right about the 13th Amendment, no injury in fact, okay? Now, by the way, if the claim had been that the draft discriminated against her because she was a woman, would she then have skin in the game? Different story. Now she does have an injury in fact, right? She's over 18 and she does have an injury in fact. And I submit to you, you know, if we ever see the instigation of the draft again, right now the draft is only males have to register as of now. But it's not as if, you know, there's any harm. It's not as if we're sending any troops anywhere who are drafted as a result of it. But if there's ever a war and people are drafted for the war, there would be a very valid claim of discrimination on the basis of gender. Because now many women want to have the opportunity to go into the armed services. Okay, let's move on to prudential standing. And as I said, I have a fair amount of ground to cover here.
So C is correct, right? Yeah, it wasn't A, it was C, right? Yeah. Yeah, good.
Constitutional standing is set forth in Article 3. It is a constitutional bar to someone's ability to bring a lawsuit. Okay? Not the case with prudential standing. Prudential standing says that sometimes, even if you have constitutional standing, we are creating these 3 areas where we don't want you to bring the case. It is not worth our time to deal with your type of case. Okay? This is a little bit more controversial than constitutional standing. Some people think it's judge created, not created by the Constitution, as constitutional standing is. And some folks believe that this is just a way for the federal courts to not have to deal with too many cases. And I've given you a critique of prudential standing by this Professor Todd Brown, who says, you know, really, everyone who has the right to bring a case should be permitted to bring a case. He doesn't say it, but doesn't Marbury versus Madison say that? If someone is harmed, the courts have to provide a remedy. That's what courts do, right? So in a way, isn't prudential standing, this would be his argument, in a way, isn't prudential standing anti-Marbury versus Madison? Don't know that anyone has raised that argument before the Supreme Court. but it's not an unreasonable one. He says, you know, it's not really standing at all. It's just, here's his words, a judicially crafted set of exceptions to the obligation to hear and decide matters that are within the court's jurisdiction. Like it or not, your duty is to learn prudential standing, even if you disagree with it. Because guess what's going to happen on the bar exam? You're going to be tested on prudential standing. And the courts are applying prudential standing, okay? So let's run through the 3 types of prudential standing that we have, and then we will run through the cases. 3 types of prudential standing are third-party standing, where someone other than the injured party is bringing the case. Taxpayer standing, we've talked about this a little bit already, sometimes called generalized grievance standing. And third, organizational standing. See if I can show you a case here. Duke Power versus Carolina Environmental Study Group. Carolina Environmental Study Group is obviously, despite the fact it is an organization that represents a bunch of people, is, despite organizational standing, being allowed to bring this case on behalf of the members of its group. We'll talk about that in more detail later on. You see an awful lot of cases called the Sierra Club versus so-and-so, Judicial Watch versus so-and-so. The ACLU versus so-and-so. Those are obviously organizations that have been allowed, that have standing, have prudential standing, in spite of the organizational standing ban, to bring these cases on behalf of members. And we'll get into that in just a minute. So let's state this slightly differently. As a general rule, third parties don't have the right to sue on behalf of others. That would violate the third party standing, prudential standing rule. As a general rule, your status as a taxpayer alone is not enough for you to bring a lawsuit claiming that a law is invalid. There's an exception to that we'll talk about. And finally, as a general rule, organizations cannot bring lawsuits on behalf of their members. The members who are injured must bring them themselves. Again, there's an exception to that we're going to talk about as well, okay? So that's sort of just framing the question here. Now let's go through these one by one, and I'm going to get you the elements which you are going to commit to memory before you take the quiz, okay? Third party standing. Here, a person other than the injured party is bringing the action. 2 elements have to be met if a court will allow that person to proceed. If not, third party standing will have the lawsuit dismissed. Number 1, there has to be a close relationship between the injured party and the third party bringing the case. This is usually a relationship where the third party is in a position of advocacy, protection, or there's a fiduciary relationship between the third party and the injured party. The doctor-patient relationship is one of those. We'll see later on, potentially an attorney-client relationship is another. Shockingly, we're going to find a bartender-patron relationship is okay in some circumstances. Okay. So you first have to have that close relationship. Second, the injured party is usually prevented from bringing the lawsuit himself or herself because of some impediment. The impediment is sometimes financial. The impediment is sometimes your desire to protect your privacy and avoid embarrassment. You can see that one applying in the doctor-patient relationship, right? It's the doctor brings it on behalf of patients who suffer from this disorder, but it's a little bit embarrassing to admit that you have this disorder. This is clearly the case, as we're going to see in abortion cases. Women who have abortions don't necessarily want their names to be disclosed to the public because it's a matter of privacy. They consider it to be a matter of privacy. They would rather not sue at all than have their identities disclosed in many circumstances. Okay, so that's third-party standing. Close relationship. The injured party faces an impediment that makes it extremely difficult or impossible for him or her to bring the case. The second is taxpayer standing or generalized grievances. As the general rule, status as a taxpayer by itself does not confer standing to sue the government. The courts consider these to be generalized grievances. They're generalized grievances because they are claims shared with all other members of society, all other taxpayers in society. The big fear here is that, okay, I want you to think about your town. Who here has ever gone to a town meeting? Okay. Who here has ever gone to a town board meeting of some type? The finance committee, the planning board, the board of appeals, the school committee, the board of selectmen, you name it, right? You know who's there all the time. That guy. You know that guy. He shows up at every single hearing. He wants to run the freaking town. He thinks even though he lives on the other side of town, he has the right to object to you to putting an addition on your house. He thinks that even though his kids are not in school, he has the right to tell the school committee how to run their schools. And what's that guy going to do if he doesn't get his way? He's going to sue. And what's going to happen to the courts? They're going to be filled up with tons of that guy who are bringing lawsuits that they don't have an interest in. That's the whole idea of taxpayer standing. In Massachusetts, we have a phrase: you cannot bring a lawsuit if you're acting as a private attorney general. It is the duty of the attorney general to enforce the laws and to determine which laws of the Commonwealth are not constitutional. Not every single citizen in the country gets the right to be a private attorney, and in the state gets the right to be a private attorney general. Otherwise, the courts will be filled with private attorneys general, or who I just called that guy, okay? I've seen women who are that guy as well, just so you know. But they're usually men who are that guy. They like to hear themselves speak. Now, there is one exception to taxpayer standing. It's the exception created by the case of Flast versus Cohen, which we'll talk about shortly. It says that if a taxpayer is challenging government appropriations under a claim that they violate the Establishment Clause of the First Amendment, then taxpayer standing is enough. In other words, you can't spend my tax dollars on religious activities. There are a panoply of religions in this country, and quite frankly, I'd be more inclined to allow taxpayer dollars spent on my religion than your religion, which means tax dollars should be spent on no religions, right? Would be a strict reading of the Establishment Clause of the First Amendment, favoring certain religions, or favoring religion in general over no religion, so to speak, okay? So that's sort of the thrust of what's being claimed here. Now, I will tell you that Flast was established in 1968. We're going to take a look at two additional cases that on first glance would seem to fall within the Flast exception, but the Supreme Court went out of its way to take them both outside of the Flast exception. and say that the taxpayer standing rule prevents these lawsuits. All right? Now, the third and final is organizational standing. As a general rule, organizational plaintiffs may not sue on behalf of their members. The members are required to sue on their own behalf. However, if these three elements are met, organizations, and I've mentioned a couple of them, the NRA is such an organization that brings lawsuits, the Sierra Club, Judicial Watch, the ACLU, the Appalachian Mountain Club, the Audubon Society, we can go and name them all, right? Okay. Those are the ones we're talking about that are involved in organizational standing. The exception occurs when all three of these requirements are met. Number one, at least some of the organization's members have standing themselves. So for example, if it's the NRA and they're claiming that a state law or regulation violates Second Amendment rights, at least one member of that chapter of the NRA must have a injury in fact, causation, or redressability, must have constitutional standing to go forward with the case, all right? Second, the suit relates to the organization's general purpose. So can the NRA bring a lawsuit claiming that a lumber company's free cutting of lumber in a national park violates the law? And the answer is no. Because what is the general purpose of the NRA? The general purpose of the NRA are training in the use of firearms, and more recently, preserving gun rights. What the hell does that have to do with cutting down timber in the environment, right? On the other hand, would the Sierra Club meet the second prong of this test when it comes to cutting down trees in the forest? Yes, because that's within its general purposes, preservation, of the outdoors, preservation of the environment and the outdoors, okay? And then finally, and this one is almost always met, the members themselves are not needed for adjudication. They're not necessary parties for adjudication. Considering broad discovery that occurs, you can almost get the discovery from these members to show what their injury would be. They're very rarely needed for adjudication. So you need to know all three elements, but it's the first two that really come into play. Are we ready to go through some cases here? Let's go. I'm going to go through these very, very quickly. I'm going through these quickly because I want you to see the facts. Where are the facts going to appear again someday, potentially? On the bar exam, right? Singleton versus Wolf. Missouri physicians, doctors bring a case challenging a Missouri statute that prohibits abortions that are not, quote, medically indicated from the purposes for which Medicaid benefits are available to needy persons. Just so you know, Medicaid is health care for the indigent. It is both a federal and a state program. The federal government provides a bulk of Medicaid funds, but the states themselves are required to come up with a significant amount of the money that covers the medical expenses of indigent people, okay? So it's sort of a joint federal state program. In Massachusetts, we call Medicaid Mass Health. That's the name of the agent, the sort of the state-run program that deals with it. State seeks to dismiss on the ground that although some of the plaintiffs' patients might have standing to bring the suit, the physicians did not. This is a third-party standing claim, okay? By the way, would the Missouri physicians have sufficient injury, in fact, to bring the claim themselves? Yeah, Carrie just said financial, and that's right. If typically these statutes are looked at limiting the number of abortions that occur within the state. Here specifically the number of abortions that state Medicaid will pay for. We'll see now that Medicaid generally pays for no abortions, but we'll talk about a few of those cases later on. Obviously, the Missouri physicians who perform abortions will perform fewer of them and therefore not make as much money. A loss of money is always injury in fact. So there's a financial stake here. But the question is, can the doctors bring the case on behalf of the patients? And here the court says yes for two reasons. Number one, it's a close relationship. It's a doctor-patient relationship. It's normal for doctors to advocate on behalf of their patients. It's normal for patients to accept doctors' advocacy in these situations. There is a fiduciary relationship. The patients rely on the doctors quite a bit. Number two, obviously the question of abortion involves some degree of privacy over your medical history. You guys know about HIPAA, right? Every time you go to the doctor's office, you have to sign a form in which the doctor says he's not going to give out your records, but he can use them for normal purposes, sharing them with other people in the office and other doctors and the like. So we do value our medical privacy in this country. And if someone had to come out and sue on their own, their name would be the lead name as a plaintiff, and there goes the privacy. Everyone knows that the person wants an abortion, right? So there's your impediment. Both parts are met, okay? Barrows versus Jackson, 1953 case. The date is important because we were still, Brown versus the Board of Education didn't come down until 1954. And we were still generally facing segregation and racism in large parts of the country. Barrows owned a piece of land. He was Caucasian. When he bought the land, he signed a restrictive covenant. We covered those in real property. For those of you who have had property, those of you who haven't, you have something to look forward to. In the old days, before they were declared unconstitutional, in a lot of situations, Caucasian owners of property would agree that they would neither sell nor lease to persons of color. That they would be unconstitutional today in virtually every circumstance. And we'll talk about this later on when we do the state action doctrine as well. So here Barrows apparently leases the property to a person of color. His association goes crazy. They sue. As a defense, Barrows raises the rights of African Americans in general not to be discriminated against from such discriminatory restrictive covenants. The defendants seek to dismiss, claiming lack of prudential standing. You don't have third-party standing. And it would look like, you know, at sort of superficially, the impediment part of this is easy for Brown, okay? And that's because of contracts. If you're not a party to a contract, do you have the right to sue to claim that that contract is unenforceable? And the answer is no, there's no privity of contract, right? So here, persons of color would not be in a position to claim that that restrictive covenant is harming them because they're not a party to the restrictive covenant and they can't enforce it. And the court says, well, then this can't be enforced by the party himself, it would have to be enforced by a third party. So that's a pretty significant impediment for the lessee, for the person who's renting, who's African American. He won't be able to bring this case himself, okay? Now this one has a little bit less, in terms of facial appeal, a little bit less of a close relationship than the doctor-patient relationship. There's not normally a close relationship between a landlord and a tenant. There is often a contentious relationship between a landlord and a tenant. but the court seems willing to overlook that here. Sometimes you're going to believe that these decisions are outcome driven, and you'll see that the courts will relax standards a little bit. The court here says, sort of glosses over the closeness of the relationship, but I think because the only way that this is going to be declared unconstitutional is to allow this Brown fellow to bring the case himself. So the court says that there is the exception to third party standing rule applies here. Now we're really going to stretch the relationship, I think, a little bit. Craig versus Bohr in 1976. We'll deal with this again when we get to the Equal Protection Clause and when we deal with gender discrimination under the Equal Protection Clause. The question here is whether a bartender has standing to sue on behalf of patrons who have been denied the ability to drink. Oklahoma had a law that allowed women to buy low alcohol beer when they turned 18, but prevented, I say men here, when I was 18, I was not a man, but men don't get the right to purchase any alcohol in the state until they turn 21. And the justification for this is that men are less mature when they're 18 than women, and the insurance statistics used to tend to show that young men get in more accidents than young women and tend to drive drunk more often than young women as well. So the bartender brings this action on behalf of all his customers who would be able to drink if they were women, but they're men. They're between the age of 18 and 21. The state looks to dismiss the case, saying that there's no standing. You don't have third-party rights to bring this case on behalf of those people. We clearly have the impediment, right, here for them to bring it. Well, actually, we don't. I mean, someone who's 18 can file a, by the time 1976 came, the age of majority in the entire country was 18 years of age. So someone who's 18 in 1976 could have brought the case themselves. But the financial impediment probably would have been an issue in many circumstances. The real question is, what kind of a close relationship is there between a bartender and a patron? Does anyone here have a bartender? In the old days, people used to say, oh yeah, that's my bartender. You know, and it's like I'd go to the bar and I'd sit at the bar and my bartender would give me advice. You know, or I'd tell all my woes to the bartender and the bartender would listen with a sympathetic ear, so to speak. But again, the court seems to gloss over this to let the case go forward. And we'll talk about the substance of that case when we get to equal protection. Gary Gilmore was a notorious murderer back in the 1970s. A little background information. In 1972, the Supreme Court declared the death penalty to violate the cruel and unusual punishment clause of the Eighth Amendment. In 1976, it reversed itself. Gary Gilmore became a nationwide, went on a small murder spree, became a nationwide phenomenon when he was caught, essentially because he said he did not want to contest his death penalty sentence that he had received. He wanted to be executed, essentially. And I have this cartoon up, which is probably in a bit of bad humor. But the reason that this is up is because in 1976, the state of Utah used the firing squad in order to execute people. Very few states were still doing hangings at that time. Many states were still using the electric chair, lethal injections were starting to become sort of the most I don't want to say popular, but the most common method of execution by that point. But Gary Gilmore did not challenge the sentence, just wanted to get it over. His mother had different feelings. His mother sought to intervene on his behalf, and she asked for a stay. In a 5-4 decision, the court refused to hear the mother's claim. This is an easy case from the purpose of standing. The mother should not have third-party standing for an adult who doesn't have any impediments, right? Now, until Gary Gilmore turned 18 years old, did Gary Gilmore, could the mother have asserted the type of close relationship that the law would recognize? And the answer would be, of course. But after he was 18, Gary Gilmore was emancipated and not within his mother's, purview anymore. So what probably made this a 5-4 decision, my guess is, instead of a unanimous decision, is that I think, the decision to go back to the death penalty was a 5-4 decision. And I think many of the justices were still sort of anti-death penalty were on the court at that time. And that's kind of, I think probably reflected in the decision. So here Gilmore actually wrote a letter to the court saying he wanted to die. The court says he clearly does not want to, there's no contesting what's going on with him. The mother doesn't have that relationship in the case. There's no impediment preventing him from challenging his death penalty, and he's chosen not to. So we don't fall within the third-party standing rule. Anyone know what Gary Gilmore's last words were? Let's do it. Remember what I said? I mean, he had this odd fascination with wanting to be executed. And right up until the end, he wanted to be executed. And it was in all the newspapers, caught everyone's attention. United States versus Richardson. This is someone who's got a 1974, obviously, Vietnam was still going on. There was the secret bombing of Cambodia. There were, unfortunately, some bad choices that the intelligence agencies had made that had come to light, intervening in countries and things like that. And so Richardson had a gripe with the government in general, and didn't like the policy of the covert operations of the CIA, so went on a mission to try to get the CIA to produce documents and show how the money is spent. And this is a taxpayer standing case. And the court says you're basically just trying to bring this case as a taxpayer. You show no actual harm to yourself. This is a generalized case. So we are not going to give you taxpayer standing. Then we come to the big case that creates the exception to taxpayer standing. Now look, I'm going to give you the Flax versus Cohen test. It's a two-part test. I don't often tell you this, but I'm going to tell it to you now, okay? This is not a test that you have to memorize. What you're going to need to know for the bar exam is that if there's a question of taxpayer standing, the only time the Supreme Court is willing to allow an exception to that is when a person is challenging a congressional appropriation that is used in claimed violation of the Establishment Clause, okay? And the two cases that follow this, Roberto? Yeah, the only time that there is an exception to the prohibition on taxpayer standing cases is when the plaintiff is claiming that a congressional appropriation of money was made in violation of the Establishment Clause of the First Amendment. So this was a case where money was used to purchase textbooks and other instructional materials that were used at parochial schools, religious schools. And Flass brings an action challenging that. And the court says, yes, you can go ahead and do that. It establishes this two-part test, which is not even a real understandable test. Taxpayer must establish a logical link between his or her status as a taxpayer and the type of legislative enactment attacked. And 2, the taxpayer must establish a nexus between his or her status as a taxpayer and the precise nature of the constitutional infringement alleged. Okay? And again, that's a test I'm not going to require you to memorize. What I do want you to know is that these 2 cases that follow put the brakes on Flass. In the Hine case, which came down in 2007, the court said we are not extending Flass. This involved George W. Bush's executive appropriations that were made for his so-called faith-based initiative. George W. Bush believed that it was more beneficial for the government to give money to private organizations to do social good than to give the money directly to people to do social good. He wanted to channel it through these organizations. A large number of them were faith-based organizations, Catholic charities, missionaries, things like that, okay? And what you're going to see in these 2 cases is that the majority of the Supreme Court creates these fine distinctions. So here's what they say in Hine. Flass doesn't apply because Flass was about a congressional appropriation of money. This money is not coming from Congress, not coming from the legislature. This money is coming from the general fund of the president's office. Now, some would argue that's a distinction without a difference. Violation of the Establishment Clause is a violation of the Establishment Clause.
Can you say that again? I don't think I got it.
I don't know what you're talking about. Which part did I say?
Was it Congress that if Flax doesn't see it as?
So Hine says the distinction is that Flass was about congressional appropriations of money. Hine is not about congressional appropriations of money. It's about executive spending of money from the executive branch's general fund. Okay?
Thank you.
Again, a very fine distinction in the eyes of many. What it's telling you is the majority of the justices don't want to extend Flass anymore, not even a smidgen, but they don't want to overrule it either. And Thomas and Scalia would have overruled it. They wrote concurrences. Same thing in Arizona School Tuition Organization versus Wynn. Here, Arizona gave tax credits, state tax credits, for people who made donations to STOs, school tuition organizations, the vast majority of which are religiously based. The Supreme Court says, once again, a tax credit is not the same as an appropriation of money, okay? So that is their distinction. All right, I want to get into the ripeness doctrine and cover a bunch of these things real quickly. What you're going to see here is, first, you're going to see a lot of what I would call a lack of focus. The court doesn't seem to be consistent. And then you're going to see at the end, the court is far more forgiving when it comes to ripeness than when it comes to standing, okay? So first, the ripeness doctrine. The court will not take jurisdiction of a claim that, quote, rests upon contingent future events that may not occur as anticipated, or indeed may not occur at all. So if there's a statute that says a criminal statute that prescribes some activity that I've never engaged in, can I claim my case is ripe by challenging the statute and saying that's unconstitutional? It will certainly become ripe if I do the act that's unlawful, right? Or if I'm about to do the act that is unlawful, it may be ripe. But not just speculating as to whether I may or I may not do it. You'll see the ripeness doctrine occurring in administrative cases. Sometimes, say in zoning cases, you have to go through a process. In state administrative cases before you can bring a judicial action. Usually you have to get a full and final decision out of the administrative agency before you're allowed to go to court, and they claim essentially that it is under the ripeness doctrine. First case is Pohl versus Ullman. This case will be relevant later on when we do the right of privacy, the fundamental right of privacy. Dr. Buxton is involved in this case. He is a physician, an OBGYN in Connecticut, who wants to dispense contraception to his patients for medical reasons. We'll see in Griswold, some of these women had health problems that would have been exacerbated by childbirth. Connecticut banned the dispensing of contraception throughout the entire state. Buxton wants to challenge it, claiming it's unconstitutional, and the court throws it out, saying your case isn't ripe yet because you haven't actually dispensed it. Buxton says, well, I'll dispense it then, and the court says it's still not ripe because even if you dispense it, there has not been a prosecution under this statute in decades in the state of Connecticut. There is no chance that you are going to be prosecuted and end up being found guilty for prescribing contraceptions. Guess what would happen 5 years later? He'd be arrested for dispensing contraception. And that would lead to the Griswold versus Connecticut case that we're going to talk about later on, okay? Abbott Labs versus Gardner. In 1962, you guys know what this is all about, right? When you buy a bottle of Motrin, it has to tell you on the bottle that it's ibuprofen. When you buy a bottle of, I can't even pronounce the next one. When you buy a bottle of Tylenol, it has to tell you that it's acetaminophen. Did I pronounce it correctly? I might have for a change, right? It's a consumer protection thing. It tells you what the drug is, not just, you have to say what the established name is, not just the proprietary name of the drug. And it's done for good purpose. So the drug manufacturers want to challenge this law, and the claim here is the case isn't ripe because the law is not going to be implemented for years. But the court here, they're starting to get forgiving. The court here says, look, for these people to do their labeling, they have to do it a long time out. So this is going to affect them in the short term, not in the long term. And so the case is going to become imminent. So we hold that this case is ripe. On the other hand, we're going to get a couple where you just shake your head. United Public Workers versus Mitchell. This one less than the next one, to be honest. Lawsuit challenges the constitutionality of the Hatch Act. Hatch Act has been in the news lately. It provided that this part of the Hatch Act provided that federal employees could not take active part in the management of political campaigns or participate in political campaigns. So if I work for the federal government, I can't be a campaign manager or even be a fundraiser or even be a person who gets on the phone and tries to raise money on behalf of that campaign. I'm not allowed to engage in that. That sounds like a huge violation of the First Amendment right of free speech, okay? Just because you're a federal employee, you don't have the right to engage in political speech. And political speech is a very highly protected form of speech. So this is challenged. The court says, sorry, your case isn't ripe. You have to get fired first for your case to be ripe. Or you have to be disciplined by your employer first for the case to be ripe. This one's not exactly consonant with the ones we've just seen. And I submit to you this one as well, International Longshoremen versus Boyd, 1954. This case is about Alaska. Got Alaska on the map. I got a grizzly bear. I got Alaska king crab. Who is that in the bottom right-hand corner? That is actually not Sarah Palin. That's Tina Fey. Sarah Palin actually did not say I can see Russia from my house. She did say I'm very close to Russia where I live, but she didn't say that. That was a spoof. I've always been amazed by how much Tina Fey looked like Sarah Palin, though. Just shocking to me. One time on SNL, they brought them out together, and it was hard to tell which was which. Alaska was not a state, and you've got some legal immigrants in the United States, resident aliens, and they want to go work in Alaska. I think this was a little before the time of the pipeline. People went up there and made a ton of money on the pipeline. But they wanted to go work in Alaska during the summer. They were afraid that if they went to Alaska, which was not one of the, the continental 48, was not a state yet, that they would be refused re-entry. Because how do you get from Alaska to the States? You have to go through Canada, right? That they would be refused re-entry when they came back. So they brought the suit seeking a declaratory judgment that they would be allowed back into the lower 48 when their summer jobs were over. Boy, it pretty high price to pay. Justice Frankfurter writes the opinion, and he says the case is not ripe. Won't be ripe until you go and you try it. And then if you can't get in, then you can bring the lawsuit. You know, and that doesn't seem to be the way we've been looking at it in some of the other cases. This is the so-called Conrail cases, the regional rail reorganization cases. I guess the government essentially took a lot of the property of Conrail, devoted a lot of it to Amtrak, and then made Conrail share a fair amount of the tracks with Amtrak, gave some benefits to Conrail. Conrail was more of a freight moving service than a passenger service. Conrail was not happy with this and wanted to challenge it. And there was this reorganization plan that would talk about how the property would be taken, what would happen. And they bring a lawsuit challenging it. And the plan had not been formulated, and it would be some time before it was. And what the court says here essentially is, even though really facially it appears to be unripe, how can you challenge a plan that doesn't exist, right? That seems like off the top of your head, that's pretty straightforward. But what the court said here was, well, they're kind of challenging the overall taking of the property, and this is inevitable. It's going to happen, so we're going to let them go forward. Exact same holding in this Lake Carriers Association versus McMullen. If any of you own a boat, and the boat has an enclosed toilet, not a porta potty, but a toilet with a holding tank, you can't just dump it into the ocean anymore. You have to go to a pump out facility. These folks have challenged it. The defense is going to take some number of years before we're going to implement it anyways. So your case is unripe, and the court says, no, it's inevitable. They can go forward. The most recent case is 2014, the Susan B. Anthony list versus Driehaus. Here, so there's this congressperson from Ohio, Steve Driehaus. He lives in a very conservative district, a very pro-life district. And Driehaus himself tends to be pro-life. The Susan B. Anthony list purchases advertising on billboards in the district. And apparently Driehaus had voted in favor of a health care bill that made some changes to Obamacare. And what they claim on the billboard is, shame on Steve Driehaus. Driehaus voted for taxpayer-funded abortions. and they took the position that the bill supported taxpayer-funded abortions. As it turned out, the bill did not, and the Susan B. Anthony list was wrong. There's a law in Ohio that prohibited, what am I trying to look at here? Prohibited, quote, false statements during a political campaign. Driehaus claims that this is a false statement. He files a complaint with the Ohio Elections Commission. There is a probable cause hearing, which is not a final result. And they say that there's probable cause to proceed because this looks like a false statement. And the Susan B. Anthony list responds by filing a lawsuit in the federal court seeking an injunction against the Ohio Elections Commission from proceeding, with this administrative action. Now, as a general proposition, one has to exhaust one's administrative remedies or the case isn't right. If there is an administrative case going on before you get judicial review, you've got to get a final decision out of that process before the case is right. That's called failure to exhaust your administrative remedies. The Supreme Court seems to throw that right out the window here. Supreme Court says, apparently, and by the way, just so you know, this is a clear violation of the Susan B. Anthony's list, First Amendment rights. You know why? You're going to be shocked by this when we get to the First Amendment. I have a constitutional right to lie. The First Amendment protects lies in most circumstances. There are some circumstances it doesn't quite clearly, for good reason. I can't perjure myself in court, okay? I can't defame someone. But generally, there's this case that we'll look at, the so-called stolen valor case, where there were laws that said that people who claimed they won military awards they didn't win could be prosecuted. And those are overturned because I have a First Amendment right to lie, for the most part. That's how broad our First Amendment is, or at least is supposed to be. So in this case, clearly, they thought there was enough interference with rights, just making them go through the process. CAPE was right for review. Credible argument, credible threat of enforcement, threat of future enforcement of a false state statute is substantial. Okay. There we are. We'll see you on Tuesday. Patriots have their first game this weekend. Go Pats. Apparently, I forget, where are they playing? They're playing in a stadium that's allowing some fans. Oh, they're playing Kansas City. That's going to be an interesting one. Oh, no, Kansas City is tonight. Yeah, that's right. That's right. Kansas City is going to have, in any event. Bye-bye, folks. That'll be interesting. Virtual football.